5 seconds to go. Start. By way of this petition filed under section 115 of the Code of Civil Procedure, the petitioner has prayed for the following relief. It is therefore prayed that the petition may kindly be allowed in view of the submission made herein above and order dated 13th June 2019, Annexure P4, passed in ex petition number 29 of 2004, titled as Surtu Devi versus Sukhram, may be ordered to be set aside and quashed in the facts and circumstances of the case. Brief facts necessary for the adjudication of the present petition are as under. A decree for possession of land bearing Khasra number 805 measuring 31217 bighas and Khasra number 899 measuring 212 bighas situated in Mohal Darat Bagla, Tehsil Joginder Nagar, District Mandi, Himachal Pradesh, has been passed in favor of the respondent decree holder by the Court of Learned Civil Judge, Junior Division, Joginder Nagar, on 30th November 2012, which judgment has attained finality as the appeal preferred against the same by the defendant stood dismissed. These facts are not in dispute. Thereafter, an execution petition was filed by present respondent decree holder for the execution of the decree. Wide Annexure P2, objections were filed against the same by the present petitioner judgment debtor inter alia, taking the stand that after the passing of the judgment the matter stood compromised between the decree holder and the judgment debtor, and decree holder had held out that the decree shall not be executed and that the suit land shall be partitioned. In the reply which was filed to the objections by the decree holder, it was specifically denied that any compromise was ever entered into between the parties. Record demonstrates that thereafter the matter was listed on several dates before the learned executing court for consideration. On 7th March 2017, the objections were heard and the case was ordered to be listed for orders on objections on 29th March 2017. However, on 29th March 2017, no orders were pronounced on the objections and rather the learned executing court passed by the following order. The case is listed for order on objection. However, issues are not yet framed. Now, to come up for settlement of issues on 20th May 2017, the grievance of the petitioner is that despite a specific express order having been passed by the court that issues were required to be framed on 7th May 2019, learned executing court all of a sudden passed the following effect. The case was inadvertently listed for determination of points. However, there is no need of determination of point. Let case be listed for consideration on 30th May 2019. Stop.